We've been talking about the gun and magazine ban lawsuit in the Southern District of Illinois. 4 cases consolidated, and the state has filed their nearly 1,500 pages of stats and various historical analysis and consultants information. They're getting upwards to $750 an hour to provide testimony. One individual getting $1,600 a day to travel and provide testimony. And there's about 5 different consultants doing that on the state side. But again, your tax dollars used to defend the state's gun and magazine ban and registry. While you've also got private dollars being used to challenge the state's gun ban and registry. Todd Vandermyde, he is the host of Freedom's Steel on YouTube, and he's a longtime gun rights advocate, a former contract lobbyist for the National Rifle Association, but also he was with the Federal Firearms Licensees of Illinois. I connected with him to get his initial reactions to this, and kind of, just what's your initial first blush as to what's going on here with the filing from the state of Illinois?
This looks to be almost 1,500 pages of throw the spaghetti up on the wall and see what sticks. I don't think they took the judge's admission or admonishment to heart in this at all, because I would not be, you've asked for an oversized brief. We gave you 70 pages there, and now you just, and I understand that the illustration portion that the judge asked for would be significant, but this seems to just go beyond.
So again, Vandermyde talking about how there's a lot there. There's 1,500 pages or so of different types of filings and stats and all of that. But what about the arguments? What are the arguments that they ultimately do make, especially when it comes to the Bruin arguments that a lot of the gun rights advocates are saying changes the calculus, so to speak, on how these things are to be argued in courts?
Well, they continue to try to reshape the test that was announced in New York. They sat there and said that it is text of the Second Amendment, then informed by history and tradition. And they keep trying to write it, as it has to be a firearm in common use for self-defense. That's not the test at all. Heller was very explicit when they said for lawful purposes, such as self-defense in the home. They keep trying to use in the home and self-defense as limiting factors on the other lawful purposes. The other lawful purposes are collecting, it could be self-defense, practice, all that kind of stuff. And they're trying to get the text of the Second Amendment strictly down to possession within the home and some limited self-defense issues. They're not going into everything else that's a lawful, practice of, and just because somebody may not pick up an AR and point it at a home invader, I don't think you can discount that leaning it up against the wall in the corner of the bedroom doesn't mean that you've got it there poised for a self-defense usage. And they're trying to really get down into the weeds. And we've seen this in a couple other states where they want to, it has to have been actually used in an active shooting or something like that. And, we cited about half a dozen cases or so, and they're trying to say, see, that shows this doesn't happen. And they just want to completely, I've talked about this before, those 2 words, such as, they just want to erase from the Heller decision.
So Todd Vandermyde, gun rights advocates, talking about the arguments the state's making in their filing yesterday against a preliminary injunction in the Southern District. And he goes on to react to the statistics, the different hundreds of pages of filings that were showing all kinds of mass shooting statistics and making arguments using those statistics. Do those statistics circumvent constitutional rights?
I don't think so, because it's the interest balancing is out the door. You look at Bob Morgan's exhibit, whether you want to call it an exhibit, a declaration, or whatever, it's 96 pages long. The lion's share of that, I think he's got 7 pages of his personal testimony, and then the rest are copies of bills that he filed to ban this stuff. What does that have to do with anything? I think, the environmentalists, the Sierra Club, ought to be screaming about the number of trees they're killing to do this. But I look at that and I see some of the stuff, and I think it's irrelevant. They put in something that's like 100 pages of news clippings about Highland Park. It's not really relevant to the test at hand. I think they try to bootstrap in a dangerous and unusual claim. They try to get to a statistic on AR firearms and say, well, there's only X percentage across the population. That's not in common use. They completely ignored the Supreme Court in Catano, where they said 200,000 stun guns was enough to make them in common use. They completely ignore, they try to revive and breathe life back into Freedmen, saying that, these were not in common use in 1791. They were not around in 1791, which is not the test at all. You apply what they want to the First Amendment, and the internet, radio, television, Twitter, all the like don't obtain First Amendment protections. How ludicrous is that? That's exactly, Justice Scalia said some have made the argument bordering on the frivolous. Well, they have jumped straight to frivolous.
So Vandermyde talking again about the arguments that the state's making, and will they hold water? Vandermyde predicts that it won't hold water. What about the argument that the M16 is only slightly different than the AR-15? Vandermyde says that argument is really non-consequential, he argues.
No, because the problem is that's exactly why M16s are regulated under the National Firearms Act. That's why Tommy guns are regulated under the National Firearms Act. They were full autos. I mean, if you think about the 5 categories of things, you had full autos, you had suppressors, you have short-barreled rifles, short-barreled shotguns, and destructive devices, which are grenades and explosives. So those were all the, components of what we commonly refer to as the giggle switch is what has got them regulated under that. And I don't see that being, they're trying to make that's the only difference, and therefore that's why these things are the kissing cousins of whatever. And no, I don't think so, because had that been the place, they would have added a lot more types of guns. The National Firearms Act was originally going to try to regulate handguns, and rifles and all that stuff got thrown in as an afterthought. So no, I think they don't understand the National Firearms Act, and I think their argument here is specious. I think they're just trying to sling as much garbage up against the wall to see what the court may potentially bite on, given what the judge did in Naperville.
I got a text here about that particular question from a listener saying an M16 is the same as an AR-15 is like saying a Honda Civic is like an Abrams tank. All right, I guess that's one argument. We'll hear more from Todd Vandermyde coming up next here on WMAY. Stay tuned. It is Springfield. All right, so the more than 1,500 pages of filings in the state's arguments against a preliminary injunction. There's about 5 or 6 different experts, consultants that are ranging from $250 an hour to $750 an hour. One of them charging $1,600 for travel and testimony. And that's obviously part of what is just stacks and stacks of documents. Now, the federal judge said he didn't want to be papered to death, but he got about 1,500 pages dumped on him yesterday. So we'll see how that goes. Hearing a bit from Todd Vandermyde and his response, in particular his response to the consultants getting hundreds of dollars per hour.
If I get into the expert witness field, my fee should be higher. the state is playing with our money. The state has an unlimited budget essentially, and they don't care. And they're just trying to gin up whatever they are. I think that one expert out of California has been sidelined because of the social media outcry against him. And the state's just playing with our money. That's what you can do when you have a blank check.
So Vandermyde goes on to discuss what's next here in the arguments and in the filings, and for the plaintiffs, what are they going to be doing? What are those next steps?
Right. So we now have 21 days to file our response. I think we are going to, I'm giggling at some of the things they put in their illustrations. I don't think they understand the pile of horse manure they've just stepped in, and they're going to get an education. And I'm looking forward to that. I think that I think half their brief is wasted. I see where they're trying to go, but I think they're taking a very long and, I'm going to get the wrong word, circuitous or, kind of route to get there. They seem to think that, it's Chevy Chase, and the shortest distance between two objects is a line in the opposite direction. So we're going to file our stuff. We will, we have the experience of having, Maryland behind us. Some of the attorneys involved in one of these suits are arguing that case. We have the experience of our legal team having dealt with California. So I think we're going to have an all-star team there that's going to be able to do it probably in less words and more succinct, and make some very poignant points to them as they've tried to reformulate what the court said in Heller and New York and completely ignore Catano.
Now, one thing that you got to consider, too, is the timing of all of this. All right, you've got October 1st being the window opening for when people have to register weapons, and then it's by January 1st of 2024 when you have that deadline to register those weapons. Vandermyde said there's another deadline to worry about here as well.
Well, don't forget that in the mid part of April, all the other personal restrictions kick in. So, one of my carry guns is illegal for me to carry under Illinois law. You've got all that stuff going on. You've got how's this going to impact, shooters who come in from out of state for matches and the like.
So obviously a lot of time-sensitive things happening here. Let's take one quick call. You've got about 30 seconds. Go.
Morning, Greg.
Hey.
Hey, so I did about 11 years in the military, and I carried everything from the M16, the M4, to just full-out machine guns that were fully automatic.
15 seconds.
The M16 and the M4 are semi-automatic, except if you reverse that lever all the way back, you get what you call a 3-round burst, which means 3 rounds come out. It's not very accurate.
Yep.
I'm a gun advocate. I'm not trying to step on anybody's toes here, but I just wanted to clear up the whole deal between the M16 and the AR-15.
Understood. Appreciate the call. Got to take a break, and we obviously have a lot more about this in the days and weeks ahead.
From the Fly SPI Studios, take the easy way.